Question 1. A key factor in the independence of an AML audit is that the auditor should: Option A. Have never worked in previous assignments within the AML/CFT departments. Option B. Have been screened by the board of directors before the audit starts. Option C. Have no involvement with the organization's AML/CFT compliance staff. Option D. Be sufficiently trained in AML to be able to provide an independent review. The correct answer is option D. Be sufficiently trained in AML to be able to provide an independent review. An auditor in an AML audit should be sufficiently trained in AML to be able to provide an independent review. Adequate training enables the auditor to assess compliance effectively and ensures that their evaluations are credible and informed. Choice A is incorrect because while it is preferable for auditors to have independence, previous work in AML/CFT departments does not automatically disqualify them from conducting an audit if they maintain objectivity. Choice B is wrong as screening by the board of directors does not guarantee the auditor's independence. It may even compromise it if the board holds undue influence over the auditor's decisions. Choice C is incorrect because while involvement with AML/CFT compliance staff should be limited, having some level of communication is often necessary to understand the audit context, provided it does not compromise the auditor's impartiality. Extended rationale: the correct answer remains D. Be sufficiently trained in AML to be able to provide an independent review. The best way to analyze this question is to identify the precise AML, compliance, investigative, regulatory, or financial-crime principle being tested and then connect the facts in the stem to that principle. The correct option is the strongest choice because it most directly addresses the specific circumstances described in the question. In professional compliance work, conclusions should be based on the complete pattern of available information rather than on a single isolated fact, and the same approach is useful when answering examination questions. The other answer choices may contain concepts that are valid in different circumstances, which is why they can initially appear plausible. However, a distractor should be eliminated when it introduces a different legal process, investigative step, risk indicator, reporting obligation, authority, or control than the one actually described in the stem. A useful exam strategy is to compare the defining feature of every option with the strongest clue in the question. The correct answer should fit those facts without requiring assumptions that the question never provides. From an AML and financial-crime perspective, unusual activity does not automatically establish criminal conduct. Financial institutions generally assess activity in context by considering factors such as the customer's known profile, expected transaction behavior, source and destination of funds, ownership information, products and services used, geographic exposure, transaction frequency and size, supporting documentation, and applicable regulatory requirements. When the observed activity differs materially from what would reasonably be expected, the institution may need to conduct additional review, document its analysis, and follow its established escalation or reporting procedures as appropriate. For examination purposes, focus first on what the question is specifically asking the institution, investigator, compliance officer, or other party to identify or do. Next, separate the facts that are merely background information from the facts that actually determine the answer. Finally, test each option against those decisive facts. Following that process confirms D. Be sufficiently trained in AML to be able to provide an independent review, as the most precise response. This reasoning method is valuable because it helps distinguish closely related AML concepts and makes the underlying principle easier to apply when a future question presents the same issue using a different scenario.